Dear viewers, welcome back. As you already know, under the AI Act, classification of AI system designed on a risk-based approach can be represented as a pyramid. In this video, we will focus on the AI systems which are in the two last layers of this pyramid. In other words, I will talk about the rules applicable to limited risk AI systems and minimal risks AI systems. The category of limited risks AI systems, also called certain AI systems, encompasses four types of AI systems intended to interact with natural persons and/or to generate content. The following systems are in this category. First of all, AI systems that are intended to interact directly with humans. This targets, among others, chatbots or digital assistants like Siri or Google Assistant. Second, AI systems, including GPAI systems that have the capacity to generate synthetic audio, image, video, or text contents. It includes many generative AI systems, or GenAI, such as ChatGPT, Gemini, and Midjourney. Then, two different AI systems that use biometric data, which are personal data relating to physical or behavioral characteristics of natural persons, like fingerprints, face images, voice, or typing dynamics. More specifically, emotion recognition and biometric categorization systems are aimed. The first is defined as an AI system capable of identifying or inferring emotion based on biometric data. The second refers to systems that can, based on biometric data, assign natural person to a category, for instance, gender, age, eye color, or ethnic origin. And finally, AI systems used to generate deepfakes. This last category refers to the use of an AI system to manipulate or generate contents that resemble existing persons, places, or events, and would therefore appear to a person to be authentic rather than AI modified or generated. So, the use of GenAI, where capable of generating deepfakes, is therefore also included. The EU legislator knows that these systems present transparency risks. Physical persons can be misled and think that they interact with a human rather than with an AI system. AI-generated content, and especially deepfakes, can also be deceptive by blurring the lines between synthetic and human contents and can therefore facilitate large-scale misinformation and manipulation. Moreover, it has long been recognized that biometric data, like face images or voice recording, can be collected without the knowledge of a person. In order to manage the specific risks posed by these systems, the AI Act contains transparency requirements. These requirements must be fulfilled by the provider when the system is a chatbot and by the deployer when one of the above-mentioned biometric systems is concerned. In addition, transparency of generative AI system is ensured both by the provider and by the deployer of the system. These general transparency requirements take different forms depending on the kind of limited risk AI systems and actor concerned. Therefore, the deployers of biometric categorization systems and emotion recognition systems must notify natural persons when they are exposed to these systems. Regarding deployers of AI systems intended to interact with natural persons, the obligation implies to develop and design it so as natural persons interacting with the systems are fully informed and aware that they are interacting with AI, unless where it is obvious considering the context and circumstances in which the system is used. Turning now to providers of generative AI systems, they must embed technical solutions that enable marking in machine-readable format and detection that the output, i.e. the produced content, has been generated or manipulated by AI systems. In other words, they must ensure technical traceability of the AI-generated nature of the content. To do so, the use of technical solutions such as watermarks, fingerprints, and cryptography may be relevant. Lastly, deployers of Gen AI system must disclose the synthetic nature of the content in two cases: when the system generates deepfakes and when the system generates text used to inform on public interest topics. This would, for instance, be the case where a press agency uses AI to generate press releases. In general, and for all limited risk systems, requirements apply to the way in which this information must be provided. From a formal point of view, the information must be clear and distinguishable. From a temporal point of view, it must be provided at the time of the first interaction of a person with the system or when a person is exposed to the system for the first time. With the exception of chatbot-like systems allowing to report offenses, all limited risks AI are exempted of the transparency requirements when used to detect, prevent, or investigate criminal offenses. Additionally, providers of Gen AI systems do not need to reveal AI manipulated or generated nature of the content in the cases where their systems do not substantially modify the input data. To us are, among others, concerned AI systems improving the resolution of images or use for spell checking purposes. Regarding deployers of deepfake systems, their requirements are reduced when the deepfake is obviously a part of an artwork. For example, if a movie contains deepfakes, it could be disclosed in the credit. Lastly, deployers of AI systems generating text to inform on public interest topics are exempted of their transparency duty where the following cumulative conditions are met. First, the AI-generated text is human-reviewed, and second, the editorial responsibility for the publication is fully assumed. As already explained in a previous video, the boundaries between high-risk AI and limited-risk AI are not hermetic. In some cases, requirements of high-risk AI systems may apply to limited-risk AI systems. Let's illustrate this principle with the following example. A public authority decides to impose use of a chatbot to citizens requesting welfare allowance. In principles, chatbot-like systems fall in the category of limited risks. However, systems used by public authority to evaluate eligibility of natural persons to public assistance benefits is considered as high risk under the third annex of the AI Act. In this case, the provider of the systems needs to comply with the specific transparency requirements applicable to limited risk AI systems. But these requirements will apply in addition to the rules mandatory for high-risk AIs. Additionally, it is important to note that, as recalled in the AI Act, deployers of limited risks systems may also be subject to other transparency requirements stemming from EU or national law. Thus, complying with transparency requirements of the AI Act does not exempt to comply with data protection requirements or consumer protection rules. Any AI systems that do not fall in the category of prohibited, high risk, or limited risks under the regulation can be qualified as minimal risk AIs. While no specific requirements are imposed to these systems, the text nonetheless contains provisions that apply to them. To that extent, the text gives suppliers and deployers the opportunity to draw up codes of conduct, either individually or in partnership, and, if necessary, in cooperation with civil society and researchers. In particular, the purposes of these codes are the voluntary application to minimal risk AI systems of requirements applicable to high-risk AI, e.g. human oversight, technical documentation drafting, and cybersecurity requirements, and the voluntary application of rules specific to minimal risk AI. Member states and the AI Office, a branch of the EU Commission which is explained in another video, are entrusted with the mission of encouraging and facilitating the drawing up of these codes of conduct. Thanks for watching, stay tuned!